Wait, did the Supreme Court just do this overnight? That is the question racing through legal circles, government offices, and quietly through everyday life across the United States right now. There was no long build-up, no weeks of televised arguments, no countdown that warned the public something this big was coming. Instead, the decision arrived fast, through the court's emergency process, and by the time most people noticed, the ground under American law enforcement had already shifted. On the surface, the ruling sounds technical, even boring. It does not announce a new law, it does not strike down a famous statute. But history shows that the most powerful changes often hide in procedure. Laws matter only when they are enforced, and this decision rewires who controls that enforcement, how quickly it can be stopped, and who gets the final say when power is challenged. For years, one quiet but powerful tool shaped national policy. When a federal law or executive action was challenged, a single district judge could issue an order blocking it everywhere in the country. It did not matter if the case involved 10 people or 10,000. One courtroom could hit pause on a nationwide policy. Supporters said this was necessary to stop unconstitutional actions immediately. Critics warned it gave individual judges authority that rivaled Congress and the president combined. That tension has been building for decades. Different administrations faced the same tactic, just from different sides. One judge in one district could reshape national immigration policy, healthcare rules, environmental enforcement, or labor regulations overnight. Slowly, this extraordinary power became routine. Emergency orders became strategy. Forum shopping became normal, and the system drifted further from its original design. Then the Supreme Court stepped in, and it did so fast. Through its emergency docket, the court made clear that this practice had gone too far. Judges, the majority said, are meant to resolve disputes between the people in front of them, not to manage national policy. When courts issue orders that protect people who were never part of the case, they stop judging and start governing. And that, according to the court, crosses a constitutional line. This matters because judges are not elected. They do not campaign. They do not face voters. Their independence protects fairness, but it also means their power must be carefully limited. The ruling signals that nationwide enforcement decisions should come from elected branches, not from a single judge acting alone. The dissenting justices saw something very different. They warned that limiting this power could allow unlawful government actions to continue for months or years, while lawsuits crawl through the system. They argued that nationwide court orders have often been the only realistic way to protect large groups of people who cannot afford to file dozens of lawsuits across different states. In their view, the court just removed a critical safety valve. This clash is not really about procedure. It is about trust. Trust in courts versus trust in elections. Trust in judges versus trust in political accountability. And the Supreme Court just made its position clear. The speed of the decision is what shocked even seasoned legal observers. Emergency rulings are supposed to be rare. They are used only when waiting would cause serious or irreversible harm. By acting this quickly, the court signaled that the existing enforcement framework itself had become a problem. Not one policy, not one president, the system. Almost immediately, the effects began spreading. Federal agencies started reviewing enforcement programs that had been frozen nationwide for years. Policies, once considered dead, suddenly had a path forward in many regions. State governments began reevaluating how they challenge federal authority and how aggressively they enforce their own laws. Legal teams rewrote playbooks overnight. For law enforcement agencies, this changes everything. A single ruling is now far less likely to shut down an entire enforcement strategy nationwide. That may lead to more confident enforcement in some areas. It also opens the door to uneven application, where a law is enforced aggressively in one state and limited in another. The same rule, two realities. Businesses are already bracing for impact. Uniform nationwide pauses once meant predictability. Now, companies operating across state lines may face different enforcement rules depending on geography. Compliance becomes more expensive. Legal risk grows, and uncertainty becomes the new normal. For ordinary Americans, the consequences may feel invisible at first, but they are deeply personal. Laws affecting jobs, healthcare, education, immigration, environmental protections, and voting rights may now depend more heavily on where you live. Two people under the same federal law could face completely different outcomes simply because they cross a state line. Supporters of the ruling call this a return to constitutional order. They argue that federalism was always meant to allow variation and that courts should not impose uniformity through shortcuts. If national consistency is truly needed, they say, Congress should clearly legislate it instead of letting judges fill the gaps. The majority opinion leans heavily on that idea. Uneven enforcement, they argue, is not a failure. It is a consequence of limiting power to where it belongs. If lawmakers want clarity, they must provide it. If voters want change, they must elect it. This ruling also shifts incentives across government. Agencies may act faster. States may push harder. Advocacy groups may need to file multiple lawsuits instead of relying on one sweeping case. Power has not disappeared. It has moved. Lower courts now enter uncertain territory. Judges must craft narrower remedies. Broad orders will invite rapid Supreme Court review. Conflicting rulings are almost guaranteed, and that means more legal battles, not fewer. Politically, accountability becomes unavoidable. When courts step back, elections matter more. Policy outcomes are tied more directly to who holds power. The court has effectively told the country that democracy, not judicial intervention, is the primary engine of change. Critics remain uneasy, and history gives them reasons to worry. Courts have often stepped in when legislatures failed, especially during civil rights struggles. Limiting that power could slow progress or leave vulnerable groups exposed. And whether that happens now depends on how responsibly elected officials act and how closely the public pays attention. But one thing is beyond debate. The Supreme Court did act fast, and the rules governing law enforcement just shifted, quietly, suddenly, almost overnight. This was not a headline designed to grab attention. It was a structural reset, and its consequences will shape American life long after the shock fades. So the real question is not whether the court did this overnight. It is what happens next, now that the balance of power has been moved, and whether anyone was truly ready for what comes after. What happens next is where the real story begins, because Supreme Court rulings do not end debates, they redirect them. This emergency decision did not close the door on conflict. It opened several new ones at the same time. Power that once flowed through courts is now moving back toward agencies, states, and elected officials, and that shift will define law enforcement nationwide in the months ahead. The most immediate change is how legal challenges will work. Instead of one lawsuit stopping a policy everywhere, challenges will now unfold piece by piece. A rule may be blocked in one district while fully enforced in another. Appeals will stack up. Conflicting rulings will multiply. The legal map of the country will look less uniform and far more fragmented. Federal agencies are already adapting. Programs that were paused for years are being reviewed for restart. Enforcement strategies that were considered too risky are back on the table. This does not mean unchecked power, but it does mean momentum has shifted. Agencies know that a single judge is less likely to freeze an entire system overnight. States are adjusting just as quickly. Attorneys general who relied on nationwide injunctions are rewriting their strategies. Some states will push enforcement further, knowing challenges may be geographically limited. Others will race to courts they believe are sympathetic. The battleground has not disappeared, it has expanded. For advocacy groups, the cost of litigation is about to rise. Nationwide change will now require more cases, more courts, and more time. Well-funded organizations will manage. Smaller groups may struggle. That reality worries critics who see access to justice becoming uneven, favoring those with deeper resources. Businesses are watching closely. Companies operating across multiple states now face the possibility of complying with different enforcement realities under the same federal law. Legal departments are preparing for increased complexity. Compliance strategies are being regionalized. Predictability, once a quiet benefit of nationwide court orders, is fading. For everyday people, the impact will feel gradual but undeniable. Employment rules may differ by state. Environmental protections may be enforced aggressively in one region and lightly in another. Healthcare access could shift depending on jurisdiction. Immigration enforcement may look dramatically different across state lines. Rights on paper remain the same, but how they are applied may not. Supporters of the ruling argue this is exactly how the system was designed. They say courts were never meant to act as national regulators. In their view, forcing political questions back into the political process strengthens democracy. If voters dislike enforcement outcomes, they can vote leaders out. That accountability, they argue, is healthier than judicial shortcuts. The dissenting view remains deeply concerned. History shows that courts have often been the last line of defense when politics failed. From civil rights to labor protections, nationwide court orders played a critical role. Limiting that tool could slow justice or deny protection to those unable to fight prolonged legal battles. Lower courts now face pressure from both sides. Judges must apply the new limits carefully while still protecting constitutional rights. Some will proceed cautiously, others will test boundaries. Appeals courts will see heavier caseloads, and the Supreme Court itself may be pulled back into similar disputes sooner than expected. Politically, the ruling forces clarity. Leaders can no longer quietly rely on courts to stop or sustain policies. Responsibility is more visible. Success and failure are harder to shift onto judges. That transparency may energize voters or deepen polarization. What makes this moment unusual is how quietly it arrived. No dramatic announcement, no national address, just a swift ruling that rewired enforcement behind the scenes. Many Americans will only notice when outcomes start changing around them. This is why the decision matters. Not because it settled a single case, but because it reset the rules of engagement. Enforcement is becoming more localized, legal battles more frequent, political accountability more direct. The Supreme Court did not say who should win future disputes. It said who should decide them. That distinction will shape law enforcement, policy fights, and constitutional debates for years. Whether this new era strengthens democracy or strains, it depends on what happens next. The court has stepped back, power has shifted, and now the country must decide how to use it.